I'll stand over here.
Okay.
Well, thank you so much. It's a pleasure to be here. This is a topic that I don't speak on often, but I find that some students really enjoy it. And the issue is how the topic of bioethics has interacted with the Supreme Court. And we have to remember is the very basis of bioethics is the idea that we have some control over our body. And how can the state regulate that control? We should not lose sight of the fact that our Constitution, from the very get-go, took a firm statement on how people are constituted. The Constitution decided for representation that some people will be worth 100% for representation, and so-called other persons, which meant slaves, would be worth only 3/5 of a person. And this was a fairly early and important statement about what worth each person had for the purposes of representation. And this is the 3/5 clause, and it says, no person held to service or labor. I'm sorry, that was the 3/5 clause. There was another provision of the Constitution that also spoke to this issue. It was called the Fugitive Slave Clause. The Fugitive Slave Clause. What was the Fugitive Slave Clause? It provided that if a slave escaped from one state to another, the state to which the person escaped to would have an obligation to return that person. So from the very get-go, there was this notion within our Constitution that some people did not have control over themselves, and in fact, they didn't have freedom of mobility. And if they tried to be mobile, tried to walk elsewhere, the government actually sanctioned their return. This clause was very much in tension with the Fifth Amendment of the Constitution, which says that no person can be deprived of their liberty without the due process of law. So at the very early years of our republic, we had this debate over who is a person? What is a person? Are some individuals not people? And if they're not, what are they? Property or something else? The Supreme Court's first major case on this issue came in 1842. The decision was called Prig versus Pennsylvania. And this case involved slave catching. This was an awful, awful law. The Fugitive Slave Act basically said, if any person held in service escapes to another state, there's an obligation to return that person back to his home state. Some states, like Pennsylvania, didn't like that law. Pennsylvania enacted what's called a personal liberty law. What was the personal liberty law? It said that if you want to drag a person out of our state, you need to persuade a judge. Why? Because very often, the slave catchers made stuff up. They would lie and say, oh yeah, that's John Doe, that's the guy I'm trying to catch. They had no proof. It's okay, you bring him out. So Pennsylvania said, before you drag a person from his home, show us some evidence, show us some proof. In Prig, the Supreme Court considered whether that law was constitutional. And there were two arguments, right? Hey, Alan, how you doing? Dean Mendenhall. One of the arguments was that Congress lacked the power to require states to assist with this fugitive slave law, what you might call the commandeering doctrine. And the other argument was that Congress had this power to force states to go along with this. The Supreme Court made something of a split decision. The Supreme Court said that the states could not be required to assist with the return of the slaves, but the courts, the state judges could be bound. And therefore, state judges could not require proof, evidence, before these people were returned. Now, how many of you have actually studied Prig in class. This was a very important decision. Probably most of you heard of the next case, Dred Scott. I'm sure you all say this in common law. But let me tell you something. Prig was far more damaging because it enabled the fugitive slave trade, the back and forth, to exist for decades. This was a very bad decision, one that, unfortunately, most law students never even study. The second case I want to talk about is Dred Scott against Sanford from 1858. The facts of the case are fairly straightforward. Dred Scott lived in Missouri. Sanford lived in New York. Scott sued Sanford for his emancipation. He argued that Scott had traveled to free territory, and by traveling to free territory, that made him free. But that wasn't really the issue the Supreme Court was presented with. The court was presented with a separate question. What happens when a person from New York sues a person from Missouri? We have what's called diversity of citizenship, right? We learned this in Civ Pro. But to have diversity of citizenship, you must have a citizen of one state sue a citizen of another state. Was Scott a citizen? So by the very nature of suing in federal court, the Supreme Court had to decide, were Dred Scott and his wife Harriet citizens of Missouri? And this is a very bad decision for a lot of reasons. But the court held that Scott was not a citizen of the United States and that he was not a citizen of Missouri. But Chief Justice Taney went further. Chief Justice Taney held that even a free person of African American descent could never become a citizen. Why? Taney explained that these were inferior people, that they could never be citizens, that they were mere property. And even if emancipated, they could not have the rights of citizenship. And because they were not people, they were not given the due process of law. This decision built on Prig. And it was an early statement by the court, a 7-2 decision, that certain people were not people, that they were mere chattel. There were two dissents in Dred Scott. Justice Curtis dissented, and he said that the Constitution was not made exclusively for the white race. Indeed, he was right. When the document was ratified, people of African descent could vote in 5 states. So Taney was wrong, even on his history. Justice Curtis was so disgusted with the Dred Scott decision that he resigned from the Supreme Court after Dred Scott. He said, I can't do this anymore. He resigned from the court. There was a separate dissent from Justice McLean, who wrote, a slave is not a mere chattel. He bears the impress of his maker and is amenable to the laws of God and man. So even at this early juncture, you had a 7-2 decision. Basically had 7 Southerners on the court, and you had 2 Northerners, and it split along those lines. Taney was from Baltimore, which was considered at the time a Southern state. Okay. Now, Dred Scott is no longer good law. The Supreme Court never overruled it. They didn't have to. Instead, we have the so-called Reconstruction amendments, the 13th, 14th, and 15th Amendments, which nullify Dred Scott. The 13th Amendment says that neither slavery nor involuntary servitude shall exist in the United States. Now just focus on the text, right? Neither slavery nor involuntary servitude. That suggests that involuntary servitude was something different than slavery. Slavery was broader than mere chattel slavery, sheer ownership. It referred to an entire political state of inequality, insubordination, that was now illegal, that neither the government nor private citizens could hold slaves or enforce this system of inequality. The 14th Amendment, which came in 1868, did a lot more. it made all people born in the United States citizens of the United States. Dred Scott was gone. No longer you had the situation where a person born here cannot be a citizen. And if you are a citizen and you are a person, you cannot be deprived of the due process of law. And then we get to the 15th Amendment, which entitled the right to vote without regard to race. Okay? Let's move ahead to 1905, a case called Jacobson versus Massachusetts. This is a case that's probably more closely associated with bioethics and involves a topic that's always relevant, which is vaccinations. Now, today, there are lots of people who choose not to vaccinate their children. Don't get me started on those people, but they exist. I know they exist, right? They're around, and if your kid ever gets whooping cough, you'll know why. But today, vaccines, I think, are pretty safe. But they weren't always safe. At the turn of the century, the turn of the 20th century, smallpox was a very significant disease. People would get it, and it would wipe out entire communities. So Boston and Massachusetts had a law that said, you're required to get vaccinated against smallpox. And if you don't, you have to pay a $5 penalty. Jacobson considered whether this law was constitutional. And the Supreme Court upheld the compulsory vaccination law. Justice John Marshall Harlan, the great dissenter, wrote the majority opinion. And he said the state has the authority to enact quarantine laws and health laws of every kind. Even if that meant taking a needle and jamming it into your arm, which is an intrusion on your person without question, the state has this sort of authority. And you probably all think, oh, of course the state can conduct medical procedures on you, like giving you a shot, right? It's for the public good. Why shouldn't they be able to do that? Well, the next case might give you some pause. This is probably one of the worst cases in Supreme Court history. It's got to be in the top 10. If you were to rank them, this is probably up there. Buck v. Bell, 1927. This is Carrie Buck, who lived in Virginia. The government determined that she was feeble-minded and that she was promiscuous. Why was she deemed feeble-minded and promiscuous? She had a child out of wedlock. She wasn't married. Why did she have a child out of wedlock? According to the story, she was raped. But the story goes even further than this. The state was looking for someone to try out the new law. The new law would allow the government to sterilize people who were deemed feeble-minded, to sterilize people who were deemed imbeciles, who were deemed promiscuous. And they picked Carrie. This is Carrie's daughter, Vivian. And the government wanted to show that imbecility was a genetic trait. That is, if the mother was an imbecile, the daughter was an imbecile also. So they gave the daughter, who was 6 months old, an IQ test. Huh? Now, I have a daughter. She's 14 months now. I think if I gave her this test at 6 months, she would have flunked it. But here was the test. They put a little coin from her face and looked to see if she kind of caught the glint of the coin. It was junk science. It was completely insane. So they found that Carrie was an imbecile, the daughter Vivian was an imbecile, and the mother, this is Emma Buck, was also an imbecile. Why was Emma an imbecile? Apparently she had syphilis once. It happens. But that made her that made her an imbecile. It happens. Church of Christ School, but it happens, right? It happens. So they said, aha. And this is doctor who ordered her sterilization. And it was done in the state colony for epileptics and feeble-minded. And the doctors drew this family tree of Carrie Buck. So there's Carrie, there's the daughter Vivian, and there's the mom Emma. So I want to show you something. See that little F in the circle right there? That stands for feeble-minded. So you have 1 feeble-minded, 2 feeble-minded, 3 feeble-minded. What they want to show is that feeble-mindedness was hereditary. that you needed to stop this bloodline from reproducing. That the only way to save our society from these imbeciles was to prevent them from reproducing. And this family tree led to a sentence in the opinion by Justice Holmes, who we were talking about in the car ride over. Justice Oliver Wendell Holmes. He famously wrote, and I'm not making this up, 3 generations of imbeciles is enough. We've had 3, we don't need any more. In other words, the state has a strong enough interest to prevent a 4th generation of these imbeciles from reproducing. Now, if this seems very Nazi-like to you, it is. In fact, the Third Reich put out propaganda posters that more or less mirrored the evidence put forward in this case. Again, we're talking 1927. The Third Reich came out some years later. Truly, the Nazis copied their eugenic programs to the United States. They took it to the next level. I'm not comparing the two, but they borrowed from us. Indeed, the Third Reich gave an award to the Virginia doctor who came up with this idea. He actually was given an award by the Third Reich. So this is stuff that we associate with Nazi Germany, but truly, and let's be candid, began in the United States. They perhaps expanded it. Now, at the time, eugenics was popular. This was a theory that elite sections of America held. Well, it was often called the progressive movement, but it was held pretty widely. And the idea was that you needed to stop undesirable people from reproducing. And the way to stop this was through sterilization. They didn't have really birth control. They weren't very effective, whatever they had. They had something that wasn't very effective. But this was a surefire way. In fact, they would either give a vasectomy to a man or they would basically cut the fallopian tubes of a woman. That was the procedure they performed. And this is Justice Holmes who wrote 3 generations of imbeciles are enough. The case goes to the Supreme Court, and the Supreme Court upholds this law. And the Supreme Court says, well, if we can force people to take vaccinations of smallpox, why can't we force people to be sterilized? What's the big difference? Right? You're intruding on their body. And I know you're saying, Josh, that's insane, but think about it for a minute. How do you distinguish the cases? Right? If you can do one, why not the other? Well, maybe one's permanent. Well, to cure smallpox, you have a single shot, but to cure imbecility, you need something more permanent. At the time, they believed this was science, right? This was a science of the day. And the courts were not willing to even scrutinize that science. There was one dissenter in Buck v. Bell. It was an 8-1 decision. Justice Butler dissented. He did not write an opinion, so we don't even know why he dissented. There's some thinking that he was Catholic in the Catholic Church opposed sterilization. I found no evidence of this. We don't know why he dissented, but there was only one dissent. This is an 8-1 decision. Buck is still good law today. It was actually favorably cited, he knows, in a Roe v. Wade, where the court said the state has an interest in your body, and they can kind of control what you do. So Buck is still good law. To this day, isn't it Alabama where they give people the option of being castrated to get let out earlier? Was this Alabama, Alan?
I'm not sure, but I think there was something about that.
A judge?
But that's Richard Posner's famous law review article.
No, I think this happened, I think it was in Alabama where a judge gave someone the option to get out of prison earlier if he voluntarily underwent castration. This happens, and judges still cite Buck v. Bell for that proposition, that this is a legitimate use of state authority. He wants to Google that. I can maybe check that
It
later.
happened in Massachusetts, a sterilization order.
These happen, yeah. So this case, is old, but it still exists. The next case, which also involves sterilization, is called Skinner versus Oklahoma, 1942. Skinner was a bad dude. He was convicted of stealing many more times, and he wound up in prison. And the Oklahoma government selected him for sterilization, but he fought the order. The case goes to the Supreme Court, and the state wanted to ban him from reproducing. They said he breeds criminals. The taint is in his blood. We need to get rid of his bloodline. The Supreme Court declared the law unconstitutional, but on very bizarre grounds. They didn't say the sterilization law was banned. What they said was, well, Some crimes result in sterilization, others don't, and that doesn't make sense. Either all or nothing, something like that. So the court didn't quite overrule Buck. In fact, they sort of reaffirmed it. Justice Jackson, who we also were talking about in the car, we had a good car ride over here, said that there are limits, though, to which the government can subject a person's body to experimentation. And so you're already starting to see here shreds of an insight that maybe the state should not be telling people what to do with their personal body. It's worth noting that Justice Jackson would later serve as the lead prosecutor at Nuremberg. And he was familiar, first-hand basis of what the Nazi atrocities were. This came before the end of World War II, but Jackson was thinking about these things early on. The next case needs no introduction whatsoever. It's a name that even non-lawyers know. Roe v. Wade, 1973. This was a decision that recognized that the 14th Amendment protects some right to abortion. This was actually the newspaper, the New York Times, the day after Roe was decided. Can you imagine? President dies and in almost the exact same font size, Supreme Court rules. Show you how significant this ruling was. And the court more or less said that in the first 3 months, the state cannot prohibit abortions. And in the second trimester, there are some regulations that are permissible to protect the mother's health. And the third trimester, the state can more or less ban it, but certain limitations for saving the life of the mother, right? And the Roe decision was based on a very, I don't know how to describe it, a very modern view of bioethics, right? They said that the mother and the doctor have this interest to decide how their bodies are treated, but the state also has an interest. And it balances, right? As the fetus goes further along in the process, the state's interest increases and the mother's interest decreases. And at the very end, the mother's interest is quite small and the state has a bigger interest. The opinion focused a lot on the Hippocratic Oath and the oath that doctors take to preserve life. This is actually Jane Roe. You may have never seen her before. Her actual name is Norma Mccorvey. She had a hard life. So the facts of her case were like this. She got pregnant living in Texas in the 70s, and she wanted to get an abortion. At the time, they were illegal. So she found these lawyers and asked them, can you help me, I need help getting an abortion. And they said, no, don't get an abortion, we need you, right? They needed her as a plaintiff to challenge the law. So basically, she carried the child to term, even though she didn't want it. And she gave it up for adoption subsequently. For many years, McCorvey was an advocate for the pro-choice movement for many years. But at some point in the 1980s, she had a change of heart, and she became a born-again Christian. And she became a leading opponent of Roe. And she called on the decision to be overruled. But even then, I think she was not treated well. I think both the pro-choice and the pro-life movement took advantage of her, which is unfortunate. She died a couple years ago, right outside of Houston, where I live. The next case that I want to talk about is Washington against Glucksberg. This case involved what's called assisted suicide, which now exists in a number of European nations. Generally, if you are in bad health, doctors can so-called pull the plug. That is, remove affirmative treatment. And eventually people might die of starvation, they might die of dehydration, they may not be able to breathe. But doctors generally are allowed to remove life-sustaining measures. But what if doctors want to do something else? Instead of removing life-sustaining measures, doctors want to end your life by giving you drugs that will stop your heart from beating. We're familiar with this in the context of the death penalty. There are certain things you put in your body that make your heart stop beating. Now we see today the death penalty cocktails are actually quite barbaric. They're gruesome. They inflict a lot of pain. But there are some drugs that are quite painless. I shouldn't say painless, that's not the right word, but it can be done swiftly, and it can be done quickly. Now you might ask, Josh, why aren't the death penalty states using the same drugs that they use in Europe? Because the pharmaceutical companies won't sell the drugs to them, right? There are drugs that will make execution painless, but states can't use them. That's why they use these other cocktails. Okay. In the early 90s, there was a person named Jack Kevorkian. That name might ring a bell to a few people in this room. He was called Dr. Death, and his mission was to assist people with ending their lives. These are people usually who had terminal illnesses, cancer or whatever, and they were probably not going to survive. They wanted to be put out of their misery. Now, most states, I think Alabama's in them, make it a crime to assist with the commission of suicide, right? You can't actually criminalize suicide because if a person takes their life, you can't prosecute them. Attempted suicide is a crime, I think at least. But for sure, assisted suicide is. So the question was whether the law, the assisted suicide law, was constitutional. These advocates argued that the 14th Amendment protected a right to end your life. And because the 14th Amendment protected the right to end your life, you could seek counsel, assistance from a doctor to end your life quicker, right? Rather than shooting yourself in the mouth or jumping off a bridge, the doctor can give you some medicine to sedate you and then give you some cocktail that would terminate your life or asphyxiate you. They're different, it's gruesome to think about, but there are different ways to do it. The Supreme Court ruled that the 14th Amendment, the Due Process Clause, does not protect a right to assisted suicide. Right? The court didn't get into the very weighty issues of whether suicide should be allowed. The court's approach was, this is not for us to decide. Let the legislative process decide this. They said that there's no deeply rooted right to kill yourself. This is a modern right. And as a result, it's up to the democratic process. Now, in about 2 decades since Glucksberg, there are states in this union, I think California, Washington, maybe 1 or 2 others, Oregon, thank you, where there are legal regimes in which people can petition for someone to assist them to kill themselves, to take their lives. In certain European countries, this has become quite controversial, where it's not just older people with terminal diseases, but younger people who have conditions like depression, who can petition for this process. And you have to persuade a panel of doctors, and there's review, and there's checks. But this is something that's been expanded. And we think about if a person, I put this sign in this slide. If a person is no longer willing to live, why would we do something to stop that from happening? And this is a very deep question, which I can't even graze. But I'll throw one constitutional argument out there. The 14th Amendment says that the state must provide equal protection. Protection. We often think of the Equal Protection Clause means you treat people equally, but that's not the word that you use. The word is protection. You have to protect people. From what? Violence, right? The state has an obligation to protect you from certain acts of violence. Does that include violence that you might cause yourself, or perhaps violence that you may even allow others to do to you, right? What is the state's interest in protecting people from themselves? What is the state's interest in protecting a fetus in the womb, right? What is the state's interest in protecting you from reproducing if maybe you're considered a danger, right? These questions all center on the same concept. What is the state's interest over a person's body? It's not just abortion. This goes way back to the framing and how we conceive of things. I don't have any answers here. These are merely questions to pose. But I thank you for your attention. Professor McLeod will give us some comments, and I welcome your questions afterwards. Thank you.
All right. Well, it's always a pleasure to interact with Josh Blackman in whatever context. We're glad to have him back. We were trying to figure out how many times you've been here.
2 or 3, I think.
At least 3, yeah.
Yeah.
Like a law review symposium, a couple of FedSoc events, but it's always great to have Professor Blackman around. For those of you who are encountering Professor Blackman for the first time, obviously you can see there's quite a clarity of thought and an understanding of the deeper themes of the law, which justifiably warrant him in being known as one of our great legal scholars in the United States.
Flattery gets you nowhere.
Well, it's getting me. Got me a free brunch earlier. But you know, Josh and I often find that we find it difficult sometimes to find things about which to disagree. But on this particular topic, I think we can find at least some frictional engagement, if not outright disagreement. So let me start where Josh started, with the claim that what's fundamentally going on in these cases is a question about control over one's body. The way that Josh put it is that the basis of bioethics is that everyone has some control over our body. And he very quickly moved into the obvious question, which is, who is the our? That is, and we'll come back to this in just a second, but who counts as the person who has a body whose body the law should take cognizance of? Now, I think that gets halfway to framing the question correctly. In other words, I think the question fundamentally is tied up in the body of persons. But I don't think that the status of the body of persons is determined by control or personal autonomy or one's own choices. So let me explain why I think control and autonomy can't explain what's going on in these cases. And then let me give my own account of what I think is going on in these cases. There's 2 reasons why I think control and autonomy can't account for this line of Supreme Court precedents about the body. One is it just can't explain the law. So I'll just give 3 examples of law that an autonomy principle can't explain. One is that there is no right, for both property professors, as Josh Blackman knows, there is no right of alienability in one's own body. Body parts are not fully alienable. They are not market alienable, for example. Under the Uniform Anatomical Gifts Act, many states allow you to donate organs, but the common law has always prohibited the sale of human body parts. And in many states, you're not even permitted to give, certainly not permitted to give parts that are non-fungible. The second thing that I think the control or autonomy principle can account for is, why is there no right to suicide or assisted suicide or attempted suicide in the law? This, of course, was the basis for the Glucksberg ruling, that our law has never recognized a right of suicide. In fact, suicide is understood to be, in our tradition, malum in se. It's inherently wrongful. And even though we Americans did away with forfeiture and abolition, the rather strict punishment that English common law imposed on someone who committed suicide, take away all the stuff and bury him at a crossroads with a stake through his body to make an example out of him. We Americans said, that sounds a little barbaric. And really, you're not really punishing the right person. You're just punishing the family because he's no longer around. So we did away with that, but we never declared suicide to be lawful. And it was this which prompted Chief Justice Rehnquist to say, therefore, there can't be a right as part of our legal tradition that is fundamental to assistance in suicide. The third goes to the question that's at issue in Jacobson versus Massachusetts and Buck versus Bell and Roe versus Wade, and that is what counts as battery of the body. And the reason why the consent principle doesn't work entirely here is that you, of course, can give someone a vaccine at common law or give them some sort of medical treatment if you obtain their informed consent. The doctrine of informed consent is an important legal doctrine which protects the integrity of the body. But notice, informed consent can be provided by the parents of a child. If this were fundamentally a protection for personal autonomy, why is it that one person's informed consent can substitute for the lacking informed consent of another? So I could multiply examples, but those are three that I think any account grounded in autonomy would have to deal with. The second reason why I think the control and autonomy argument doesn't work is it can't answer the fundamental question, which is at the bottom of all these cases, which I think we agree is at the bottom of all these cases, and that is, who is a person? Who is a person? If it is the case that a person is someone who is capable of exercising personal autonomy, then we might conclude that persons who are either not yet capable of exercising personal autonomy, see the unborn, small children, newborn infants, and persons who have lost their capability to exercise personal autonomy, see the infirm, the mentally ill, no longer or are not yet persons. And then we have a really hard time understanding what's so objectionable about the eugenics cases. So as a matter of principle, now as a matter of fact, obviously Carrie Buck, the facts about her case don't add up, just as the facts in Dred Scott versus Sanford don't add up. But if you had a case of someone who is in fact mentally infirm, on the autonomy argument, what would be morally problematic about that? So I think for both of those reasons, the autonomy argument doesn't work. It doesn't explain the law, and it can't answer the fundamental question, who is a person? So what does explain the lawlessness of the Supreme Court? Everybody, I think, every reasonable person agrees that the court acted lawlessly in Prig versus Pennsylvania, in Dred Scott versus Sanford, in Jacobson versus Massachusetts, in Buck versus Bell. What explains it? Well, here's what I think explains it. There's an older tradition, which was, of course, goes way back prior to the American founding and was still extant and the dominant view, at least as late as the progressive and eugenics movements of the early 20th century. And that was that what counts as a person is a natural person. Natural person distinguished from artificial persons like corporations and trusts. And who is a natural person? A natural person is, as Justice McLean said in his dissent in Dred Scott, a person who bears the impress of his maker. A natural person, in other words, is a human being. All human beings are natural persons. All natural persons are human beings. So there's an old tradition about what counts as a natural person, which goes all the way back to Aristotle and Cicero, known as the natural law tradition, which says that a natural person is an embodied being. You have a body, a natural person has a body, who is also a rational being, and that these two natures are inseparable from each other. A natural person has a body, and that's what distinguishes the natural person from an artificial person, like a corporation. A natural person also has a rational nature, can freely choose the common good, and that's what distinguishes that body from the body of an animal, like a dog or a mouse. We have no problem vaccinating mice. We don't think that's morally problematic. Why? Because a human being is radically different from an animal, embodied just like an animal, but a rational embodied creature. And the idea is that that is the fundamental basis of our radical equality as human beings. An equality not of result, but an equality which entitles each of us to the protection of the law. That is to say, the protection of the law against violence and other attacks upon our fundamental human dignity as rational beings. And now we can begin to understand, I think, the attraction of the autonomy-based argument. Because personal autonomy, though not valuable in and of itself, is an important aspect of human dignity. That insofar as we are rational beings, we are capable of choosing, we are entitled to freedom to choose, as long as that freedom is not exercised contrary to human dignity. There's another layer that's added to this, which also would have been understood, I think, universally by American jurists in the 18th and 19th centuries, And that is that Christianity comes along and adds to the natural law understanding of human beings as a rational and embodied beings, the idea that we are potentially eternal beings. This would have been almost universally accepted amongst all the dominant religious groups. Certainly wasn't completely universally accepted because you had various religious groups which did not believe in, say, the bodily resurrection. But certainly all the major established churches at the time of the American founding would have held as a matter of doctrine that the human body, though it dies in the 4 dimensions of time and space, is designed to be resurrected in a new life. And I think this is the way to understand the objections to all laws which treated the body as a mere thing, something to be utilized. Now, if you have that understanding, this explains why, for example, Prig and Dred Scott are wrongly decided. Everyone in this room has read Somerset's case and knows that the English common law prohibited slavery. Why? Because a slave, as Maclean says, is a human being, and a human being is precisely a rational, embodied being who is potentially eternal. I think this also explains why Jacobson and Buck are wrongly decided. That a human being, as a rational agent, is entitled to decide for him or herself whether to accept medical treatment. And here's the controversial part, I think it also explains why Roe versus Wade was wrongly decided and why Glucksberg was correctly decided. Because all persons are natural persons, that is natural beings, that is natural human beings, all are entitled to the equal protection of the law, regardless whether they have yet developed the ability or have lost the ability which correlates with the exercise of personal autonomy. Want a few minutes to reply, or should we just open up to questions?
I think you guys are very lucky to have Professor McLeod in your faculty. He just made it up in 2 seconds. That's real good. I do this a lot, and usually the rebuttals are like, wah, but that's good. I think we agree on quite a bit. I want to actually give another data point that supports Professor McLeod's argument. If we turn to the 14th Amendment, you all have your pocket constitutions, right? Sure. So the 14th Amendment begins, all persons born or naturalized in the United States are citizens of the United States. So it says all persons born are citizens. Now, a lot of people think, well, of course, Josh, that means that until you're born, you're not a person. That's not what it says. It says all persons born are citizens. But if you're not born, you might still be a person. Indeed, we both teach property, and one of the things we learn about property is you can leave property to a person who's not yet born. A fetus in utero is a person, and let's just say a husband is on his deathbed and his wife is pregnant and she's 6 months along. You can leave that property to that person. That's a legal person in every regard. So I do think there's a long-standing conception of personhood that's actually consistent with Professor McLeod's argument. I think our disagreement is actually very slight over what is a state's obligation for protection. What does it mean to protect? And I take a more Reconstruction argument. That means protecting some of your civil and political rights, whereas I think he is more so on the natural rights side. But I think our disagreement is slight, but I think you got a very good cross-section of thought right here, which was a very good debate. I'm going to shut up now and maybe call in some of you to ask some questions, and maybe we'll...
Before we do that,
oh,
can I just...
of course. Maybe
we can help clarify if there is a disagreement.
Yeah.
Maybe we can help clarify where the disagreement lies. So my view of the 14th Amendment, for example, as applied in the abortion context, would say that precisely insofar as an unborn natural person. Now, there's a separate question at what point the unborn becomes a natural person.
Yeah.
Right? So you mentioned the laws of inheritance or divisive request allow one to give to a natural person. At common law, you couldn't actually do that until quickening. So this is the argument why the first trimester of the pregnancy is a different creature than the second and third trimesters. After quickening has occurred, this
this being, whatever it is, in the mother's womb becomes a person
Right.
in the understanding of the law.
But the quickening is they start like fluttering around and doing stuff. That was the.
When you can feel the kicks
Yeah,
on the
yeah.
mother's belly. Right, that's right. So, so with that complication aside, would you say that Roe versus Wade, well, first of all, would you say that Roe was wrongly decided? And then secondly, if you were to say that, would you say that the matter should be returned to the states? Or rather, would you say that the 14th Amendment would require states to regulate abortion?
All right, so I'm not going to answer the question directly, but I'll frame this in two different ways. If a fetus is a person, we'll say if a fetus is a person, then the 14th Amendment Protection Clause says you have an obligation to protect that person. And the basis of protection means you're not getting killed.
Yeah.
Right, that's theory number one. If carrying a child to term, that decision is a form of liberty protected by the Due Process Clause, right? Then the state cannot deprive a person of that liberty without affording them the due process of law, which means some sort of fairness, arbitrariness. So in that case, the 14th Amendment puts some limits on the state's power over abortion. I think these are the two crystal, almost like polar opposite perspectives. To date, the Supreme Court has not adopted this equal protection argument that Adam and I are talking about. I think it might poke its head up in, maybe bad choice of words. I think it may, oh boy. I think it may make an appearance in the near future. I think the Supreme Court's abortion jurisprudence was built largely in the back of Anthony Kennedy's fifth vote. That applies to a lot of things.
Yeah.
And I just presumptively treat Anthony Kennedy opinions as non-precedential going forward. I mean, I know that sounds awful, but they were opinions not because of their reasoning or logic, but because they were the fifth vote. I don't think anything he wrote has stare decisis value with the current court.
And Justice Ginsburg has indicated she thinks it's an equal protection option.
She does.
Not a due
But
process.
Ginsburg has said abortion laws apply only to women and not to men, therefore they're per se unconstitutional. That's her argument.
Yeah.
Yeah.
Good. Should I look at the questions?
All right, let's do some questions. I'm sorry, yeah. Abortion laws only apply to women, right? A man, a biological man cannot obtain an abortion. I'll leave it at that, right? Because biological men can't get pregnant. So Ginsburg says when you have a species of laws that only burden women, that don't burden men, it's a sex-based classification, and under the Protection Clause, sex-based classifications are unconstitutional. That's the Ginsburg argument. It's never gotten more than a vote, but that's her position.
So sex-based laws are unconstitutional?
Generally, right? Generally, for example, let's say Virginia has a public school that only men can apply to, a military academy, right? The Supreme Court said that a male-only public school, a military academy, is unconstitutional. So Ginsburg argues when you have a law that only burdens women and not men, that law is itself unconstitutional.
Quickly, so we have, does that also apply to the military subscription, like how?
The draft, you mean?
Yeah.
Yes. Okay, very good question. I can answer this one briefly. It's a little bit off topic, but I'm happy to answer it. There was a case in the 80s where basically a man challenged the selective service, the draft. He said it's not fair that only men have to require for selective service and not women. And at the time, what the Supreme Court said was, well, only men can engage in combat. At the time, women cannot engage in combat. That's no longer the rule. Now, combat missions are open to men and women alike. A district judge in Houston, where I live, about a year ago, declared the draft system unconstitutional because men are excluded. Now, the remedy is you don't level down, meaning everyone gets out. The remedy means you level up, which means women don't have to enroll in the selective service. So that's the remedy. It's one of the things where, yay, now we're all equal. Yeah, when the court has an equal protection problem, you can either level down, meaning no one goes to the draft, or you can level up, meaning everyone goes to the draft. And this, I think, will be a level up. So, anyway, yes?
Something what you said earlier about the Alabama castration thing. It was signed last year, but it was only for the release of men that were accused of molesting or assaulting children under 13, and it's chemical castration. So
It's reversible. Yeah. It's what's called chemical castration, which is basically pills you take that make you unable to reproduce. But I don't know how effective it is, and I don't know. Okay. Yes, right in the front.
The natural persons argument I think is airtight. If you can fill me in on one issue, how is a baby in the womb a rational being?
Adam?
On the natural person's understanding?
Yes.
The natural person's understanding is that the nature, a being has the nature that it has because of its capacities, not because of its abilities. This is why you're still a human being when you go to sleep at night, right? So it's often, the accusation is also often falsely made against natural lawyers. Well, this is morally arbitrary because you depend upon abilities. No, it's about capacities. So a being has the natural capacities oriented toward its own ends. And a rational being has the natural capacity oriented toward the ends of rationality, that is choice and action. So the understanding of an Aristotle or Cicero or Aquinas or Justinian, I mean, all these contributors to our legal tradition was that the human status as a natural person is rooted in the natural capacity. Now that capacity doesn't always develop. It doesn't always develop in equal measure. There are often, obviously biological reasons why some people don't develop the capacity fully. As I just mentioned, every single one of us shuts off the ability for certain hours every night. And so, but the capacity is inherent in the nature of the being, and persists from either conception or quickening until natural death.
Quickening.
Yeah.
I'll come back to you in a minute. Just in the back, yeah.
Josh, thank you for being here.
Thank you.
Just fair warning, I'm on cold medicine, so if this is offensive, don't blame the cold medicine.
Okay.
I heard in your one of your recent responses this discussion of either the due process clause or the equal protection clause. I wonder if you could speak to how those clauses, from your perspective, interact and sometimes do appear to be in conflict. For example, if you look at Buckley, but also the lens of the equal protection clause, it's one sort of case. If you look through the lens of substantive due process, it's entirely different. And then even within the due process clause, if you look through Justice Holmes's lens of procedural due process, well, there were plenty of procedures, so it's fine. Can you talk about how these two clauses in the 14th Amendment, especially our students here in con law, our first-year students, many of them are in this room, they're starting to take con law.
Okay, very good.
The interaction between these two clauses in the 14th Amendment seems to be causing the court continuing trouble, doesn't it?
Okay, very good question. Let me try to unpack it one piece at a time. The 14th Amendment says that no person should be deprived of life, liberty, or property without due process of law. Generally, when we think of process, we think of procedures. You have a trial, you have a judge, you have a jury, etc. That's known as procedural due process. In Buck, there was actually a trial. A hearing was held before a judge. So in theory, procedure was satisfied. Now the bad part is this. Carrie Buck's lawyer worked for the colony. He called 0 witnesses. His only mission was to move the case along so it goes to the Supreme Court. She got no defense. In fact, it's not even clear she knew what they were doing to her. They apparently told some women that they had some pressure in their hips, they needed to do a surgery. They actually were lying to most of these women what they were actually doing to them. The second thing he asked about is what's called substantive due process. This is a notion that the word liberty in the 14th Amendment has substance, has meaning, and that some laws that run afoul of this liberty are so egregious that they can't even be enacted no matter what process is given. And then there's the Equal Protection Clause, which modern standard says you can't treat people differently. Right? If you have a man and a woman, you have to give them the same treatment. If you have a black person and a white person, treat them the same. But I think originally understood the phrase equal protection meant the state to protect your rights. I think originally understood they're reinforcing each other. If you have some sort of right, a liberty interest, and the state tries to deprive you of it, the courts can intervene to stop that deprivation. But the pregnancy one is tricky, right, under modern jurisprudence at least, because you have two competing interests. Right? It's one of these rare cases where you have both the mother's interest as well as the interest of the fetus. And maybe Adam has a better answer, but I don't have a good answer of how to reconcile the two. It's not. It's something that it's a hard question.
And what if the father?
The Supreme Court said the father has none. In a case called Planned Parenthood versus Casey, one of the laws at issue was whether a woman has to notify a husband about an abortion. Not seek his permission, it was to simply notify. I think there was also a bypass if there's some sort of abuse. And the Supreme Court said that that's unconstitutional, that the mother should not have to go to the father to seek any sort of notification. Adam, you want to add anything to that?
Well, they've all heard me teach cases, so
Okay.
they might not know my views on it, but they've heard the shtick. No, I want to give you a chance to interact with them some more.
Okay, other questions? Oh, yes.
So this, I have two questions. So what's piggybacking off of like the whole potential or capacity for rationality? Then does that mean that like certain animals can also be called? Because like they can be trained, and it's been found that some animals have a form of language that, you know, has some like rationality or like rationale behind it.
Well, certainly the appearance of rationality. I mean, the conventional understanding is that animals which are domesticated are given a con-natural ability to interact with human beings. This is the difference between a dog and a wolf, right? Dogs are entirely human-constituted species, right? The reason why we have German Shepherds and Schnauzers is because human beings intervened in nature and created a new artifact. So in other words, what appears to be the rationality of the animal is in fact the rationality of human beings, which transformed the animal from a natural state in which it had no rationality into an partly natural, partly artifactual state in which it reflects the rationality of human beings, which generated this breed of animals. This is true of carrier pigeons, this is true of dogs, this is true of domesticated cats, and so forth. And so, yeah, I mean, I'm familiar with the argument, but it's just counterfactual historically. That what appears to be rationality is conferred actually by human beings.
What about dolphins?
Pretty smart. Do they choose? Right? I mean, are they making a rational choice, or are they just pursuing their appetites in a really
Just
clever way?
flipping around.
Yeah, right. Yeah, I mean, that's the fundamental of the question, right? I mean, in the classical natural law understanding, shared by Cicero and Justinian and Aquinas and the rest, what's happening in a human action is the human is actually the generator of a brand new state of affairs which would not have existed but for the choice, the rational choice. And the claim is, whatever might be said about animals that are really, really clever, like dolphins and chimpanzees, they're not doing that. They're not building cities, right? They're not composing cantatas. They use simple tools, but they never invent the hammer or the screwdriver.
My second question is about like if a father has no right to be notified about abortion, then what gives them right after the child is born?
Right, so the question was, if the father doesn't have the right to be notified, why does he have to pay 18 years of child support? Is that what you're asking me?
Yeah.
Well, once they're born, I think even abortion supporters will argue that it's a person, right? Once you make out the gate, you're a person, and all the legal obligations attach. The question is what happens before the first breath is taken. Yes, over here.
So I think this is kind of going back to some discussions that we actually had in Foundations about how, like, the notion that there is a right answer to every case, and even talking about Rawls about the veil of ignorance, and how to come to, I guess, the conclusion that is encompassing of everyone. But the thing is, when he said, if you put on the veil, you're going to basically be me. So with all this, even with law, it seems to me that it's really opinionated. I mean, we all have our own inherent biases. So is there ever really going to be a right answer?
Olivier, I can't do this in 1 minute. Adam?
Well, the right answer thesis, of course, comes from Dworkin, right? So Dworkin's idea is you have a principle of political morality, and the law has to have integrity. All the law has to be consistent with it. So, as you just saw, our disagreement is very slight, I think, actually. But we have adopted different principles of political morality. Josh wants to stand on a choice or control or autonomy principle. I want to stand on a natural person principle. And that's going to have implications for alienability of natural body parts, right?
Yep.
Or other areas of law are going to be affected by.
Yep.
So in other words, you can't. The idea that Dworkin has there, and that Rawls shares as well, is whatever the law says, it has to be consistent with itself, and you have to be willing to accept all the implications of whichever principle you adopt. And I think what you just witnessed is two law professors trying to explain how the principle which he thinks is actually animating the law reconciles all these possibly
Sorry. Hey, I'll be right out. So sorry.
Yeah.
Thanks.
Do you want to respond to that briefly?
You know, it's been a while since I've read Rawls and Dworkin, so I think I'll let your answer stand. But I want to commend Professor McLeod. We had a rational debate. We agree on stuff. We disagree on stuff. We didn't yell at each other. We didn't throw pizza at each other. And you all asked very good questions. And I'm grateful for the opportunity. Thank you all so much.